sisters there and it's great. It was really not as much homelessness as we have.
But you're like.
Seriously, in Rome, there are fewer homeless people.
I noticed that in Montreal, which is 2.5 hours away.
Mhm.
For those of you that are joining us, we're the Mobile Home Task Force, and we're in the 5 minutes of idle chatter until which is on our agenda, which is to get people signed in and ready, and then we'll begin the actual meeting. We are live at this point. Everybody's going to Italy.
So Lindsay, my audio doesn't need to be connected, right?
I'm in Italy.
We haven't been in 12 years and
That's right.
used to go more frequently when our kids were little, but then I went to college.
Echo I had here went away, so.
Yeah.
So are you going?
Am I going?
Yeah.
Probably not. We're thinking Scotland.
I want to go to Scotland. I haven't been to Scotland. I
Oh.
want to go.
Okay, were you ready to go? We'll cut the idle chatter short. I wanted to do a brief introduction. I'm Representative Taylor. You can, Senator Harrison and Holly Major and Eric Fitzpatrick are here live, and we have a couple of people you can see them on Zoom. Mary Houghton, Sean Gilpin. And there's going to be a slight adjustment in the agenda. I wanted to go over it a little bit before we begin. For the last 2 weeks or so, I've been traveling around talking to most of the people on the task force and also visiting some mobile homes, things like this. And I think my enthusiasm or my thirst for power got carried away. And I find that the issues that I was thinking of dealing with are or may not be within our charge. So one of the things I want to do this meeting is go over our charge again and kind of carefully and make sure that we stay on track, because we have 4 more meetings and a report due mid-January. And I want to make sure we cover what is supposed to be covered according to the statute and not get wandered off into some of the things that they come up in discussions with people. And I say, we really ought to address that, but it's not in our charge, so we shouldn't. However, there are portions of our charge where things can be tucked in if they need to. One is we can make recommendations for further research. So we could put some things down there that seem to be coming up but may not need, and we don't have the time to address right now. We can just say during a legislative session, maybe you should talk about this. So we'll go through. I have a list that I put under my name under reports and resources on our website with a list of potential topics to discuss. And we'll go through those and figure out which are within our charge and which aren't, which can be tucked into the charges, and kind of get things organized for the rest of the, we have 4 more meetings coming. So the rest of the meetings, and also I want to make sure that we get the report, not have to rush the report. So the first thing on the agenda today, we'll do the regular agenda first. I think some of the talks that are being, that are scheduled at times may be shorter or longer, depending on what comes up. But basically, we have 2 things we're going to go over today. We have presentations from Eric Fitzpatrick on the current law regarding mobile home and mobile home parks. And Sean Gilpin from the Department of Housing and Community Development is also going to tell us a bit about the data that's being collected, the registry, and those sorts of things. And then after that, we'll get into, okay, what are we going to do for the next 4 meetings? I'd like to schedule those meetings, at least get tentative dates for them, and so people can plan. So with that, Eric?
Yeah, hi.
Take over.
Thank you very much, Chair, and good afternoon to committee members, listeners. This is Eric Patrick of the Office of Legislative Counsel, here to talk to the committee, as the chair indicated, about the current statutes that you have on the books now with respect to mobile homes. I should sort of before I get started, 2 things. First of all, I'm sure the committee knows the attorney in our office who has staffed this committee in mobile homes and housing in general, David Hall, recently resigned to take another position. I'm sitting in for him, and as sort of a pinch hitter, you might say, and might not be able to answer as many questions as he could, certainly, but I'll do my best. And any questions that come up that I might not be able to answer now, I can certainly take note of and then get back to the committee in the future. And also to let the committee know that it looks like we're optimistic that we've been able to hire somebody to fill David's slot. So with any luck, depending on when you were mentioning that you might schedule some meetings at the end of this meeting, depending on whether he's here or not next time, I certainly will be. And I think I have planned to come to the next couple of meetings with the new person just to try and help transition. So, but good news that permanent attorney is hopefully on the way right around the corner.
Housing expert?
With some experience, certainly. Yeah, absolutely. We're fortunate. So the other thing I wanted to note before I get into the substance of the law governing mobile homes, and I'll try and share my screen as I mention this. And this you may have noticed from the statutes that Representative Taylor shared already to the committee page, that there really are two different places in the Vermont statutes that contain quite a bit of law that governs mobile homes. And one place is in Title 10, the conservation and development portion of Vermont law. That piece of the mobile home provision deals with sort of general matters, permitting, leases, evictions, municipal acquisition of land for mobile homes. Oh, there we go. Let me try.
Let me jump in also quick and doing this and make sure people understand we're going through documents that are in the reports and resources page of our website. There's under my name, there's a statute tab that says Title 10 and Title 9. That's the documents we're going through.
Yes, thank you. And I'll be going through the same too as I do the discussion about the current status of the law, at least the statutory law. So the two pieces, one, this Title 10, conservation development, very general, very broad approach to regulations and laws affecting mobile homes, whereas Title 9, which is the commerce and trade chapter, really deals very specifically with sales of mobile homes. So it's very specifically targeted toward one element of mobile home law. So it's going to deal with financing, deeds, model forms for bills of sale, mortgages, things like that, all very much related to the transaction of selling a mobile home. That's covered very specifically in Title 9, the commerce and trade title, while Title 10 deals with very broad subjects related to mobile homes. So I wanted to note that. Now, there's some crossover. There's some places where the two chapters refer to each other, but in other places, they're quite distinct. So having said that as background, I suppose the very first piece of statutory language to point out, which I think is important, is the definition of what a mobile home is. Very important. And it's included in both these two titles of law that I just mentioned, the Title 10 conservation, Title 9 commerce and trade. Both have a definition, and this particular one is identical. That's the first one you're looking at, mobile home. And this is from Title 10 conservation development. And this is repeated, or at least cross-referenced in Title 9. So by looking at it here, we're actually covering in both places. So when you're talking about the definition, though, you'll see that in 1A on this page, it's a structure or type of manufactured home, including the plumbing, heating, air conditioning, electrical systems contained in the structure. That is, and then you've got 4 criteria right there. It has to meet all 4 of those criteria. You see there's an and after subdivision 3. So that means it has to be, it's not an or, it's an and. So each of these 4 criteria have to be satisfied in order for it to constitute a mobile home. So number 1, it's got to be built on a permanent chassis. Number 2, it's got to be designed to be used as a dwelling when connected to the required utilities, with or without a permanent foundation. So it's got to be built on a permanent chassis, designed to be used as a dwelling when connected to utilities, transportable, number 3, right? And number 4 is basically some size and dimension requirements there in number 4. So it's got to meet those 4 specific criteria. And that's one way within this definition that it could constitute a mobile home. You see, B is another possibility. And that says, all right, well, even if the size requirements that were just indicated previously, if those aren't met, it still can be a mobile home if the manufacturer certifies it with HUD, with the U.S. Department of Housing and Urban Development, and it meets certain federal construction and safety standards. So those are your two ways that a mobile home, that a structure, I should say, can be treated as a mobile home. Oops, sorry there. I want to take a moment then to look at Title IX, the other piece of statutory language that I just noted covers mobile homes. And this is the commerce piece. And this also has a definition in the very beginning, you'll see, of mobile home. First one is the one we just went through. Number one, you see mobile home as defined in 10 VSA 6201. That's what we just looked at. It has a second one, which to me at least is a little less clear. It's an unmotorized vehicle other than a travel or recreational trailer designed to be towed and designed or equipped for use as sleeping, eating, or living quarters. So it's unmotorized, designed to be towed and designed or equipped for use as sleeping, eating, or living quarters. So that's another way that something can be termed a mobile home. This brings up sorry, go ahead.
You have a question?
Do you want questions now or would you prefer to wait? I just have specific questions on these.
I think I'd prefer to wait, if that's all right.
That's fine.
Yeah. Because I want to make sure he gets through.
Yes.
Sometimes we get wandered off. on-
Yes.
So, yeah, if you can hold your questions. I mean, one more quick question, Mary, can you hear all right? There was some question last time. Is she,
Right now I can hear fine, thanks.
okay, good, thank you. Okay, go ahead.
So looking at this first piece of the definition, and I'm now looking at the language we had just reviewed. You'll see one of the things I think that comes up when one looks at that language is, well, if it meets these criteria, built on a permanent chassis, designed for use as a dwelling, transportable, is that real estate or is it personal property? And I think that's an important question because as you're mentioning earlier, Representative Carroll, you guys have a report that's due in January, and that is a specific thing that has to be covered in the report. I wasn't here at the time when the enabling language of the report was crafted, but you'll see number 3 in your charge of what it is that you're supposed to look at is the current statutory treatment of mobile homes, either as personal or real property. Very specific. So that's my recommendation would be that's something you want to address in your report. Again, I'm not sure the genesis of what the discussion was that made the drafters of this language want to include that issue. And you might have a better recollection or experience with that than I do. But regardless of where it came from, the question is certainly an interesting one. And you think about, again, you sort of describe those criteria that we just looked at. Those 4 elements could, depending on the facts, you might have think of it could be real estate, it might be personal, might not be real estate, it might be goods. So what is it that makes the difference between these two things? First question would be, well, is there anything in statute on that? Does the statute say whether a mobile home is a piece of personal property or a piece of real estate? And actually, the consumer fraud piece of this, the Title IX, you see, does say something about it. It's in subsection C. A mobile home that was financed as residential real estate shall be defined as residential real estate. So that's one way in which a mobile home would be treated as real property, if it's financed as real property. In other words, if it's a mortgage taken out on the piece of property, if it's treated in a way that one would treat residential real estate for purposes of financing, taking out a loan, making payments on a mortgage, if that's the case, then it would qualify as real property. So that's one way in which it would meet a definition of real property. I should back up for a second and say, well, one question that might come up is, well, why does it matter? Well, there's a number of reasons that it matters. And taxation is a big part of it. For example, if something is real property, then it's going to be subject to a property transfer tax if it's sold. If it's personal property, it'll be subject to the sales tax. So very different. Sales tax versus the property transfer tax. Any property recording requirements that apply with the town clerk would apply to real property, wouldn't apply to personal property. Municipal zoning ordinances would apply to real property, wouldn't apply to goods. And there's actually quite a few consequences to how it is the property is defined, whether it's real property or personal property. And helpfully, I was able to find a document generated by the tax department that talks a little bit about this. And obviously it's important to them because they got to determine how this is going to be taxed. So it's important what category it falls into. So they're quite specific, you'll see, and they use one of the criteria that we just talked about that was in the statute that we just saw. It says it's treated as, mobile home is treated as real property. This is that first sentence up there. When it is either one, affixed to land, or two, financed as real estate. We just talked about that second, right? That comes right from the statute. And that's number two, sort of jumping ahead a little bit, but that's on the lower right column. You'll see mobile home finances real estate. So if you're buying the mobile home from a mobile home dealer and financing it as residential real estate, you must transfer the home by warranty or quick claim deed. That's in the statute as well. So you have to use a real estate deed to transfer it, which obviously also would only apply to a real estate transaction, not a transaction in personal goods. And in that case as well, the property transfer tax is going to apply as opposed to the second paragraph. If it's tangible personal property, it's the sales tax that's going to apply. You'll see, though, that that's only that one criteria, one manner in which property is treated as real property versus personal property. That sort of test is only one of two. The first one is the mobile home is affixed to land. Now, that isn't in the statute. But that has been developed. I don't know this for sure. I didn't speak with anyone at the tax department, but that is a long-standing development by the courts as to how to determine, because you think about it, there's myriad of ways that I was just sort of alluding to, that whether a mobile home is real property or personal property has consequences, for tax collecting, for application of zoning, for a long list of things has come up for many, many years in court, because if it's not clear in statutes, then there's going to be a dispute about whether or not a particular consequence applies. It's often brought in court. And many of these are older cases because they happened quite a while ago. Now, there's a few more recent, but they tend to be a little bit older. But the test that the courts developed really was that, affixed to land. And it's just interesting. I found a couple of Vermont Supreme Court followed that test, as did courts from other states as well. And there's a couple of interesting ones I just thought I would read a little bit from because it kind of gives a couple of good examples as to how this works. So one is this case called In re Wiley from 1958. And this was a case where the question was whether a mobile home was personal property and real property under the Montpelier zoning ordinance. Because actually in that case, it was interesting was that a neighbor was trying to prevent somebody from citing their mobile home on their property. And they were trying to say, you can't cite it here because under the zoning ordinance, it had to be a home. And this isn't a home, it's personal property. They said it was a neighbor actually trying to stop the person from citing it. So the question came up in the court, which was, well, is this personal property or is it real property? Is it real estate? Court said, interestingly, it said that, I'll just read a little bit because it's one of those judicial opinions where the language is actually well done and interesting. So the court says there can be no doubt that while being drawn upon a highway, a trailer coach would be personal property, as would any other vehicle. As such, it would not be subject to the provisions of the Montpelier zoning ordinance. Here, however, we have a trailer coach removed from the highway, situated upon land leased by the trailer's owner, connected to the land by various utilities, used as a home by its owner and his family, and which has not been mobile during such period of use on the land. Does the trailer then, under the facts in the instant case, undergo such a transmutation as to alter it in character from personality to realty so as to become a single family house under the Montpelier zoning ordinance? The court said, yes, it was obviously a single family house, the way it was affixed to the land. And they specifically used that language. The trailer was mobile when it was brought to the lot, but the essential facts are that it was built for human habitation, has all the attributes of a dwelling, and became fixed to the realty by various connections. And that cases throughout the country use that fixed to the land test. And I just have to read a little bit more about this because it's worth a moment. They said they claim that the trailer is not a building because it is something mobile. Mobile it was when used upon the highway, but mobility ceased when it was removed from the highway, attached to the soil and used as a living quarters. A metamorphosis has occurred. The motor vehicle has become a fixed residence. And then it goes on to say that a hydroplane, when flying through the air, is not a vessel subject to admiralty jurisdiction, but when floating upon navigable waters, becomes a vessel subject to admiralty jurisdiction. Similar kind of idea, the analogy they were drawing. So where it was, and again, uses, and actually that is a quote from a New York case that the Vermont case was referring to. Again, uses the same terminology the New York case did, where it is affixed to the land by means of electric waters, water pipes, et cetera, then it's a permanent piece of the real estate. So there's a lot of history, a more recent case. I won't go into it in the same as much detail, but there in Vermont, there was a more recent case in 1977. Also, the crucial point was whether or not a mobile home was real property or personal property. Court reiterated that same thing. If it was as yet unattached to the land, then it was personal property. So again, it's this affixed, attached to the land idea. So that's a little bit of background. I think it was worth kind of digressing into that a little bit because it is a very specific thing that you're going to want to include in your report because that's what they're asking you to report back on. And fortunately, I think that whatever else you might hear from other witnesses or further testimony that might be heard, you have a good chunk, I think, of being able to answer that question now based on statute, there's a couple of cases, the way mobile homes have been treated as real property or personal property historically, and answer that question pretty well. So after that discussion in a little more detail of that particular issue, I'm going to return to the statute itself. I'll pause for a moment and see if there's anything on that anybody wanted to discuss further.
The only thing I might add is the document you just had up there from the tax department.
Oh, right.
So on our reports and resources page, if people want to look at that. What?
I guess, well, and a question I have just about the difference between personal and real property. That all sounds logical, and I can see that we need to have both definitions, or both site or situations. Do you see are you aware of any areas where those definitions are a problem? I mean, are there places where it doesn't make sense? Situations?
It's possible. I'm not aware of any off the top of my head.
Okay.
That doesn't mean they might not exist.
Okay.
What happens when a person goes, wants to get a loan? And the loan officer says, you can get not a real estate loan because that's a mobile home. Can that person say, now, according to statute, it's a home, it's real estate?
I think they could make that argument. Absolutely. Yeah. And I think the statute specifically says, if you look under the consumer Title IX piece, specifically says that a loan, a rent to buy sort of loan or another real estate personal finance loan does count as real estate. So I think they would be able to use that as support for their position that this isn't personal property. It's for realty. I itemize those factors. It's intended for me to live in. It's going to be situated on real estate, that sort of thing.
Go ahead.
It seems to me that the statute is leaving it up to lending institutions to a degree to decide whether a home is real estate or personal property, so that if somebody buys a home in a park, they may be unable to get a mortgage on it just because the lender wants to call it personal property and charge a higher interest rate. So I see that as a problem.
Okay.
All right, that's helpful.
Yeah, we can deal with that. We can get into that topic.
Great, thank you.
Yeah, it's an interesting question and one that it might be good to inquire of some lending institutions I'd be curious how they handle this because in Title IX, the language says A mobile home that is or is intended to be permanently sited for continuous residential occupancy by the owner on land that is owned by the owner of the mobile home. So in other words, it's one of those situations where the mobile homeowner owns the property, shall be financed as residential real estate, not may. Now, that's an interesting question, though. If it says shall, does that mean that the lending institution is required to do so? I don't know the answer to that, but it's an interesting question because the language certainly says shall.
Yeah, but not for a home in a mobile home park.
That's right. For the mobile home park, it's a may.
Right.
Who would we go to get that, to get more clarification on that?
Maybe Chris Delia, the Bankers Association. He might be able to, he's usually someone who can give a good sort of synthesis of what their perspective is on something.
Okay, good, thank you.
Yep. All right, so turning back to the statute for a moment. So we've been talking about the real property, personal property distinction, but we were also looking at the definitions when we adjourned to, or not adjourned, but do sidestep to that discussion. So a few more definitions that are worth noting, and I won't go through all of them, but mobile home park is worth noting. Because what is it that makes a mobile home park a park? And one of the key points there is it has to be more than 2 mobile homes. So that's the sort of numerical distinction. So it has to be this parcel of land that are single or common ownership or control that is designed to accommodate more than 2 mobile homes. Now, there's some exceptions for storage and display and agricultural employers, that sort of thing. But aside from that, generally that more than 2 is the threshold that makes it a park. Leaseholder is one of the bottom pages also should look at it for a moment, because who is the leaseholder? That could be a person who owns or rents the mobile home in the park. So it's a resident, you see that, who lawfully occupies the mobile home owned by the park owner or the owner of the mobile home. So it could be someone who's renting or who owns it. Either way would be a leaseholder. The resident, mobile park resident, you'll see in the next page, that is an individual or individuals or family who occupies the home on a permanent or temporary basis in the park. The park owner means the owners and operators of the park, as well as any person acting through them corporately. Department is a good one to, this will come up several times as we look at this. When we refer to the department, it means the Department of Housing and Community Development. So anytime you see the word department, that's who it's referring to. Same thing with commissioner, means the Commissioner of Housing and Community Development. And that was what I was going to cover in the definitions. So I'm going to move on. And what I'll do, because there's so much here, is I will generally be sort of describing the sections relatively briefly, but going through a couple of the sections in a little more detail. It seems like that might be something that would be worth hearing about. But if I either am going too quickly or haven't got into something that you want me to pause on, please just interrupt if I don't notice, because I may be looking down at my notes here. So section 6203, that all that does is it just provides that municipalities have the authority to acquire land for mobile home parks. That's provided to them statutorily. 6204, this just is describing how the mobile home chapter that you look at interacts with other laws. So there's various statements within that section about how, for example, a municipality may impose more restrictive requirements if they're than are imposed by this chapter, if they're authorized to do so, and some other statements about how this mobile home law interacts with other laws. Enforcement and penalties is an interesting section because you'll see that it actually gives enforcement authority to 2 different government entities as well as a private person. And that is done through subsections A, B, and C. So subsection A here basically says that if a mobile home park owner fails to comply with the provisions of this chapter, then they're going to be subject to what we were just looking at, which is Title IX, which is the Consumer Protections chapter, and that is enforced by the Attorney General. So this essentially, by cross-referencing that, and also in Roman numeral 3 under B, specifically provides the Attorney General with the authority to enforce violations of this chapter. And the Attorney General can get fines, and they can bring civil actions to order someone to change their conduct to get what's called injunctive relief, get an injunction to order somebody to either stop engaging in certain conduct or to behave differently. So that's A. B, though, not only does the Attorney General have the authority to enforce this chapter, but you'll see that's the department does as well in B, and that's, as we just said, the Department of Housing and Community Development. So that state agency as well can bring an action to get penalties, to get injunctive relief, to order somebody to stop their violations. And then lastly, subsection C, the leaseholder may bring an action. So that means, you know, the person who lives there, the resident, can also go to court and file a complaint that there's been a violation of this chapter going on. They can ask the court for relief, either to order that penalty be imposed, or to get damages, or to ask for an injunction to order the court to have someone stop doing a particular thing. So you got three different entities there. The AG, Department of Housing Community Development, and the owner themselves, the resident themselves, who could bring an action in court to enforce violations. Moving on, the rules provision just allows the department to adopt the rules to enforce, or to consistent with the intent of the legislature in passing the statute. They can do so, pass some rules that are consistent with the statute. They would be subject to the legislative rule process, legislative administrative rules process. The leases are covered in section 6236. Now, the requirement here, generally speaking, is that there must be a written lease between park resident and the park owner. So there has to be a lease in writing. And it has to be given to the leaseholder. So it has to be in writing, provided to the leaseholder. And generally, other than that, there are some specific pieces of what has to be in the lease written here, like, that it has to set out certain things related to, it has to be generally effective for a year. There have to be 60 days notice for a rent increase. Now, there's certain specifics, but for the most part, the section just applies a general standard, a fair and reasonable standard to what's required of a lease. So you see that it's in the subsection A, the second sentence, shall promulgate reasonable and fair lease terms. So that's your general standard that applies to the lease. It's a fair and reasonable standard. And so you might ask, well, who enforces that standard? Who decides what's fair and reasonable and what isn't? Well, as we just saw, this chapter is can be enforced by the Attorney General, can be enforced by the department, can be enforced by a resident. So any one of those folks could make a complaint if they felt that a term of the lease wasn't fair and reasonable. But that's the standard that's set out in statute here for terms of the lease. At the bottom, you'll see is an interesting piece that we'll get into a little bit later too. It goes over onto the next page. This is the provision, subsection D, that a mobile home that's in a park can't be sold, leased, or sublet without the prior written approval of the park owner. All right? So if an individual wants to sell their mobile home, they can't do it unless they get prior approval from the park owner. But there's a couple of caveats to that. You'll see it cannot be unreasonably withheld. So the park owner can't, for sort of a reason that's not determined to be reasonable, just say, no, I don't want it to be sold for whatever reason. There has to be a reasonable basis for doing it. And again, that raises the question of what is reasonable and what isn't. There's at least a little bit of an answer to that in the next section. I'll mention that when we go by. So that's essentially what there is to say about leases. As I mentioned, there are some specific provisions that are identified that have to be in it. That's subsection E here, like, identifying information, names and addresses, utility charges, et cetera. Number 5, you'll see, is what I just mentioned, this idea that that before selling it, the mobile home owner has to get permission from the park owner. That has to be in the lease as well. That's number 5. New lease terms have to be provided at least 30 days before they become effective. That's F. That's another piece that has to be in the lease itself. So moving on now to evictions. So now we get to the evictions piece. All right. Now, when can an eviction happen? You'll see that this is quite specific. Oops. Oh, sorry.
Question, Mary?
The requirement that a leaseholder has to notify the park owner and get permission before they sell the home is, if they violate that, the park owner has the right to evict, presumably the new homeowner. And it seems to me that this is also a problem with a transfer being personal property rather than real property. If it's real property, typically there will be lawyers involved who will record this thing and who will notice that the park owner hasn't given permission. If it's personal property, people just do it. And the park owner can find out months later.
Oh. That's a good point. Yeah, I think let's flag that for some clarification of the future discussion. That's good.
I'm just here to raise the problems.
Okay.
Thank you. So on the eviction piece, moving on to the next section, you'll see that they're only permitted, you'll see only in that first line, a leaseholder may be evicted only for, and then there's essentially four different reasons that a person can be evicted from the mobile home park. And it's number one, non-payment of rent. Number two, substantial violation of the lease terms of the park, or if there is a change in use in the parkland or a termination of the mobile home park. So any one of those four things, eviction is permitted, but it has to be one of those four. That's what the statute lays out. And that's the next sort of piece of the statutory language here. It describes a detailed court procedure that has to be followed. So if you're going to do it, you have to have one of those four reasons. And as to how you do it, you have to go through this process that's laid out in court. And you'll see number one, for example, there specifically says, a leaseholder shall not be evicted by force or by any other self-help measure. That's kind of my sense is that you'll see many of the portions of this statute date from 1970s, 1973 in particular is when it got enacted first. And in prior times, these self-help measures were sometimes permitted by not just in mobile home parks, but by landlords in general, so that the locks might be changed and somebody in order to evict somebody, that sort of thing. That's not permitted anymore. It has to be done through a court process. It has to go through judicial process. So in a sense, that may be archaic language that really doesn't even need to be there anymore. I'll leave that to people who know more about this than I do, but it seemed to me that self-help isn't really. Yeah.
So I'm wondering if these eviction requirements apply to someone who's renting a home in a mobile home that's in a park, or whether it just applies to the owner of the home in a park.
You mean if the owner is sublet it to somebody else, for example?
Yeah, maybe in a case where the park owner owns the building as well as leasing it to a tenant.
I think so. I would say yes, based on the definition of leaseholder. It's a resident lawfully occupying the mobile home owned by the owner or the owner of the mobile home cited on the mobile home. So they could be either a resident because they own it or a resident because they're renting it from either the owner or of the park or the owner of the home. I think that's the way seems to be written pretty broadly.
Sean, did you want?
Sure, I will jump in, and I don't mean to sound as though I'm being contrary to what was just said, because I think that is accurate. I will say, speaking from my time in the advocacy world, in practice, most should an eviction, in particular an eviction, come for a person who is a renter of the unit. Typically, they're treated under the Title IX, Chapter 137, the sort of typical landlord-tenant law. They're treated more like an apartment renter. It's basically, it tends to be whatever is kind of higher protections for the tenant tends to be what our judicial system will look at as the standard.
Yes, this is Sandrine from CVOO. Sean is correct.
Okay, good.
So just to be clear, so whichever law provides higher protection to the tenant, and do the landlords know that? That's what they're supposed to do?
Usually they don't.
I'm sorry, say?
Sandrine, what did you just say?
Usually they're not aware
Oh, okay.
of that fact.
Okay. Thank you. So that's where.
Yep.
Seem to be,
We lost you?
yeah, well, I think the
Lost screen share.
screen share seemed to be right. Trying to get back on here. Let's see.
Seeing you in the meeting and
Whoop.
Yeah, that's weird. Maybe I got disconnected somehow. Okay.
It looks like our agenda is going to go get pushed. We're going to extend this and we'll bring, and Sean Gilpin wanted to have his kind of shortened anyway, I think. So we'll pull over into that one. We may skip the break for a little bit.
I can also, depending on other people's schedules, sort of, take a break if you want to work in another witness who has a different schedule and then, pick
Okay.
up later on, whatever works. Okay.
There you are.
All right. Am I? Oh, I am, right? Okay. So let's see if I can get my screen back here. All right, success. So we were speaking about evictions, and I think I'd covered the general idea that there are 4 reasons for which the eviction could be done. It has to use the court procedure, for example. Then there's a lot of detail here about what this court procedure has to be. I won't go through that, but it's laid out in quite a bit of detail in that section. But various things, for example, that the notice of the eviction has to be given by registered mail. It has to be spent within 60 days, that sort of thing. All kinds of specifics are covered in that section of the statute. So moving on to closures, and that's something that is covered in 6237A. So generally speaking, again, there's a substantial amount of language here about the process for what has to happen for a mobile home park closure. I'm not going to get into all that. I'll just say, generally speaking, that's where all this is. So if you want the detail of it is here. And speaking broadly, 18 months notice is required to residents, to park residents, if the park is going to close. Now, the commissioner can waive that if it's necessary to protect health, safety, and welfare of the residents. But generally speaking, there's this 18-month notice requirement if the park is going to close. Now, that's not to say that this is dealing with a sale of the park necessarily, because you think about it, those could be 2 different things. It could be that the park owner has decided, I'm going to close it. I don't want to operate it as a mobile home park anymore. Or it could be that they're just going to sell it to somebody else who may or may not continue to operate as a park. So those are 2 different things. If it's a closure, 18 months notice is required. If the park is going to be sold, then you'll see separately when we get to it, there's a separate notice of intent to sell that has to be issued first. And that has to include the fact that there may be a potential closure of the park. So that has to be done first if someone's going to sell it. So 2 different things to think about there. That's the closure piece. As I say, there's a lot of detail in that section about the process that has to be followed for that. There's a section on fees as well. This specifies what fees the park owner may charge to the mobile home resident. For example, the park can't charge what's called an entrance fee. In other words, they can't just charge a fee for somebody to live there, just not connected to any cost that the park owner is incurring. They can impose a reasonable charge for the cost of service to place a home on the lot. So it has to be connected to how much it actually costs. But there can't just be some entrance fee to live there. That's not permitted. What is permitted is what's known as a site improvement fee. You see that it was in B there, site improvement fee. And that's defined in 3, you'll see. It's a fee, a charge for the cost of establishing a designated mobile home site located within the park. Could include site clearing, grading, construction of the pad, utility improvements, et cetera. So that sort of thing, a site improvement fee is permitted.
So I don't expect that we'll have an answer to this question right now, but a question that I have in regard to the site improvement fees is if once a fee has been assessed, say at the beginning of a park, if subsequent major improvements occur, maybe 20 years after, can a second fee be imposed? And the reason I'm asking is because a lot of parks need infrastructure improvements. And so this would be one way of getting back that cost. So that's just a question in my mind that I wanted to share.
Good. Well,
Makes sense.
flag it, keep it.
Okay, so moving along from the fee issue, there's at least the resident can't be restricted from who they're choosing to use as a vendor by the park owner. It's a pretty self-evident statement there. So now getting to this issue of sale, which we had alluded to a little bit earlier, when the homes inside the parks are sold, when the owner, the homeowner, the mobile homeowner wants to sell their home in a park, then they have to notify the park owner before they do it. We mentioned that a moment ago. But, and this is, remember, the standard what was said at the time was that under the previous section of the statute, that the park owner can't refuse to sell the mobile homeowner's ability to sell unreasonably. Remember, that can't be unreasonably withheld. Their consent can't be unreasonably withheld. So it adds a little meaning to what that unreasonable withholding language might mean in subsection B by saying the purchaser. So in other words, the mobile owner wants to sell it to somebody else. That would be the purchaser. The purchaser can't be refused entrance except for the inability of the purchaser and the purchaser's household to meet the terms of the proposed lease or to qualify under a valid admissions policy of the park. So in other words, someone who wants to buy it can't just be random. The park owner couldn't just, for some purely subjective, unrelated reason, say, oh, no, you can't sell it to that person. Remember, first of all, use the term, they can't unreasonably withhold their permission. And this specifically says they can't be refused entrance except, and what are the reasons that they can be? They can't meet the terms of the lease. So that's one, right? If they can't meet the terms of the lease, that could be a reason that you could say we can't sell to that person. They can't satisfy the lease requirements anyway, or they don't qualify under a valid admission policy of the park. Again, there's some lack of definition there as to what is a valid admission policy. That's something that could be enforced again by the Attorney General's office and the Housing Department. But there is some limits there on when a park owner could deny a mobile homeowner's intention to sell their home. So that's that piece. Now we're going to go on to access. This means the rules for when and why a park owner can enter the homeowner's lot. Right. So there are lots in the park. When can they go in? Well, first one, obvious, by consent. Right. So if the homeowner consents, well, then they can go in, obviously. And it also says that consent can't be unreasonably withheld. So there's a little limitation there on when the mobile homeowner could say, well, I just don't want you in. You can't do it for no reason whatsoever. Can't be unreasonable. Second reason, the second way that they could do it is with 12 hours notice. That's B. So if you get 12 hours notice, they can enter to do one of these four things: inspect the premises, make repairs, supply services, and show it to other prospective tenants or purchasers. And there's a couple of circumstances, C and D, that allow for limited circumstances without notice. The park owner could enter into the lot, and usually that involves some kind of emergency, either a threat to somebody's health or to the property itself that's of an emergency nature. All right, moving on again, this is a piece that we've covered before. This is section 6242, but this puts a little more detail on this idea that we talked about, that the park owner must provide notice of their intent to sell. Oh, I'm sorry, I misspoke there. This is different. This is not a sale by the mobile homeowner. This is a sale by the park owner. Different. So again, we had referred to it earlier when we were talking about whether the park owner was going to close the park. In other words, they might keep it, but they just didn't want to rent it anymore as mobile homes. This has to do with what if they're going to sell? And if the park owner decides they're going to sell the park, they have to provide this notice of intent to sell to all the residents and to the commissioner. So the commissioner has to know if there's going to be a sale of a mobile home park because the park owner has to let them know. And then there's this long and lengthy procedure that the rest of this section really addresses, which is that there's this 45-day period after the park owner provides that notice where they can't sell it. So for 45 days, they provided notice, hey, I'm intending to sell this mobile home park. They can't do it for 45 days. And during that period, this process is set up for the mobile homeowners to be able to buy it themselves. So they've got this window when they can have an opportunity to purchase it themselves. And the park owner is required under the statute to negotiate with them in good faith. So they're going to have to be, if they don't have to do that, but it provides them an opportunity to purchase it if they're interested. And the quite a bit of statutory language follows after that just sort of deals with that process and how it works. Well, that brings us quite a bit forward. Security deposits. Security deposits are defined, which is obviously an advance that's refundable when the occupancy expires. So they make this advance, oftentimes a first month's rent. And this section describes when security deposits may be withheld and the process that's required for withholding them. There's generally 4 reasons to see there for why the park owner might withhold a security deposit: non-payment of rent, property damage, non-payment of utilities, and expenses for cleaning up the place, removal of rubbish, that sort of thing after the person has moved out. And then there's a lengthy process for how it is you have to itemize how much these withholdings actually cost so that you can return the balance of the security deposit to the homeowner. So that security deposits, that's going to bring us down to illegal evictions. This is essentially what this is. It prohibits the park owner from shutting off the utilities or denying a resident access to their mobile home except through judicial process. So again, that's kind of limitation on what had happened, I think, more frequently long ago as to when landlords or property owners might take steps like this to limit a tenant's access to property. Not done anymore, not supposed to be done anyway, because it's supposed to be judicial process through the court through which someone can obtain an eviction. And this is just clarifying that that's the way it's supposed to work. And the next section even says remedies. So if the park owner tries to do that, then they can be sued. So that's what that remedies provision talks about. We have a section here that's basically just providing that a park owner can't retaliate against a resident for doing things like filing a complaint with a government agency or organizing a renters association, things like that. If the the mobile homeowner wants to do that, then they can't be retaliated against by the park owner for that. We're not moving now to the issue of abandonment. This is defined, and this basically defines when a mobile home in a mobile home park is deemed abandoned, and there's consequences to that, because if that happens, then the park owner can sell the mobile home that's been abandoned. And we'll see when we get to, and this section deals specifically with the park owner's ability to do that. There's also a separate section, which we'll get to in Title IX, in which the municipality can also sell a mobile home if it's been abandoned, if it's also subject to delinquent taxes. So the municipality can also do that. So there's 2 separate processes here. This one deals with the owner of the mobile home park's ability to sell if it's abandoned. And you'll see that the definition of abandoned is what comes first. There's 2 different ways it could be abandoned. Number 1, there's all 3 of those criteria are met. Reasonable person would believe that it's not occupied as a residence. The rent is at least 30 days delinquent. And the park owner has attempted to contact the resident without success. So all 3 of those things, that's one way to show abandonment. Number 2, another way to show it is that the mobile home has been the owner has been evicted from the mobile home park. And for at least 3 months after that, after they've been evicted, they haven't taken the mobile home away. So after they've been served by a writ of execution, after they've been evicted. So the way the eviction process works, the sheriff has to serve process that says, hey, you've been evicted. And then 3 months after that, the person still hasn't removed their mobile home, then it can be treated as abandoned. So that's another way that can happen. So if it is abandoned, as I mentioned, the park owner can sell it. That's the next section. This whole section sets out a detailed procedure for how that happens. There must be a court order at a public auction. So public auction is required. The court order must precede the public auction. So that's be the park owner goes to court and asks for an order to sell the mobile home because it's been abandoned. If the court finds that it really has been abandoned based on the criteria that I just mentioned, they can issue an order that it's going to be sold at public auction. That order has to be posted in the mobile home itself, as well as in the newspaper. So there has to be an order that's actually affixed to the mobile home that says this is subject to a public sale because it's been abandoned. This public auction must be held. This is over subsection H is an interesting point that public auction has to be held within 15 days after that court order approving the sale. So the court issues an order, says there's going to be a sale. Auction has to be within 15 days after that. So we're going to move actually. So the Brett is going to go fairly much more quickly because these are just more general statements. Just one thing I'd add here on subsection I there. Although generally speaking, the public auction is required in order for the sale of an abandoned mobile home. There is one exception for that, and that's if the mobile home is unfit for human habitation. That's the standard that's used, and there's some factors listed here that would go into the determination of whether a particular mobile home was unfit for human habitation. All right. So what if the rent is going to increase? That's what this section deals with. All rent increases must be provided to the tenants or the leaseholders at least 60 days before the increase is going to go into effect. So you got a 60-day notice period, and it has to be on a form developed by the department. So presumably the department has developed a form that has to be used to notify the residents about any kind of rent increase. All right. Now, if the rent is increased and the increase is more than a certain consumer price index threshold, and this is in statute in subsection A there. So there's this threshold that the statute establishes related to the consumer price index. And if the rent increase is more than 1 percentage point above that, then there's a lengthy process here set out that allows the residents, the leaseholders, to dispute the increase. So that's basically what the next several pages of the statute is about. They can join together as a group and dispute the rent increase. And this process is set out for how they do it. The first step is mediation. That's the section that you're looking at right there. If the mediation is unsuccessful, then the statute provides for resolution by a court. So if the mediation doesn't work, you go to court to try and work out the rent increase. That's the next section. And then the last couple of sections of this piece in Title 10 are here. So there's a registration requirement in 6254. So all park owners have to register with the Department of Housing and Community Development every year. So they have to register with them, and they have to generally pay a fee. So the registration includes various information about the parks, the number of residents they have, all that sort of information, dates that the park was established, that kind of thing. And then you'll see on the next page that the department, there it is. So the department may charge a fee of no more than $12 for each lot in the park. So $12 for each lot is the amount of fee that can't be charged, and the fees go into a special fund, and the department can use the special fund to administer this law that we've been looking at. So they obviously need staff to administer the law, but perhaps they're bringing enforcement actions. They can use the money that's created from this fee to fund that. I think Representative Taylor, you had mentioned this too, when we were looking at it. I noticed the same thing as I was looking at it, the fact that an interesting feature of that fee, I have no idea why, the sentence sort of right in the middle that says the park owner shall not be charged the fee for any mobile home park in which all the mobile homes are owned by the mobile home park owner. Not really sure why that is, but I noticed the same thing. It sort of jumped out at me too. There must be a reason for it, but it's an interesting feature of the fee system. So, lastly, habitability. So this subchapter basically is just talking about the obligations of the resident who lives in the park, as well as the obligations of the park owner. The resident can't create or contribute to non-compliance of the premises with building, environmental, housing, health rules, that sort of thing. Can't disturb the peaceful enjoyment of the premises by other owners. So that's set out in statute. And the park owner has to maintain premises that are safe, clean, and fit for human habitation. That's known in sort of landlord-tenant law and legal terminology as a warranty of habitability. The place must be habitable, has to be safe, clean, and fit for habitation. And that can't be waived by private agreement of the parties in the lease. That's a requirement no matter what. If that you'll see the next section, if that habitability provision is violated, the resident, the leaseholder has options for withholding their rent, getting a court to order that the problems be fixed, that sort of thing. As well, there's an ability of the resident to make minor repairs of minor defects and deduct them from the rent if the park owner doesn't do that within 30 days. So if it's minor, then they can do it themselves and deduct the cost from the rent. Last couple of things, condemnation and relocation of residences basically provides that the park owner has to relocate the residents if the park is condemned by the government. So in other words, the government condemns it because of some public health hazard, then the park owner has to pay to relocate the residents. And if any government findings, for example, that could be made in connection with a condemnation proceeding, that a mobile home park is in violation of health and safety regulations, have to be recorded in municipal land records. So there'll be a record of the fact that this park was in violation of public health laws. And that's pretty much it for Title 10. And pause there for a moment or jump right into Title 9, which is actually much shorter. So that'll be a quicker walkthrough, though I can also take a pause if you want to.
I have questions on 10. I think we should just jump into 9.
All right, sounds great. Let's see. All right. So again, moving on to Title 9, which is commerce and trade. So these are specific legal requirements for sale. So this deals very specifically. You're just dealing with all sorts of broad topics related to mobile homes. This is going to be more targeted. It's relating to sales of mobile homes. And we already talked about the definition of mobile home. Remember, we went over that earlier. How that, at least in part, uses the exact same definition that is used in the Title 10 provision that we just looked at. We also looked at the language here that provided that if it's financed as residential real estate, it is treated as real estate. That's subsection C. And then moving on specifically, as I mentioned, sales is what this subchapter deals with. Talks about what there has to be, if there's an appraisal, what has to be in it. The sales price must be disclosed in writing. This is for a new mobile home. If there's a new mobile home, it has to be posted on the mobile home itself, the sales price, so that a possible purchaser can see it right there in writing. There is a bill of sale required for all transfers of mobile homes. So you see that in subsection B. This bill of sale has to be provided to the town clerk and the purchaser. So they both have to get copies. And the clerk records it in the land records so that there's a copy of it there. Now, the bill of sale has to contain certain things, and you'll see that subsection C talks about that, what information has to be in the bill of sale. And there's a lengthy list of the sort of identifying information that you would expect to be in there. And perhaps most importantly, the statute includes a form. And that's and has to be, you'll see this, and we often use this sort of language while we're drafting, but we will say that the form you'll see has to be substantially in the following form. So in other words, there may be minor technical changes that have to be made in certain circumstances, but substantially, in other words, the substantive pieces of it have to be in this form. And you'll see it's quite lengthy and it's quite detailed. So it's set out quite clearly what the bill of sale form has to include. Again, a lot of identifying information and other facts about how the buyers are taking title, whether, it's joint tenants, that sort of thing. Location, size, color, where the town is, that the intent is that it be located. So quite a bit of information. It's the bottom here. Yes. So that it's an interesting point here is that you'll see when mobile homes are transported on the highway on trucks, sometimes the bill of sale has to be carried. It's according to this statute. The bill of sale has to be in the possession of the vehicle that's hauling the mobile. So they'll know right then who has purchased it and where it's going to be located. We're moving on now to, so that's the bill of sale. Now the next piece is talking about rent to own agreements. Now this is, you think of it, it's sort of like an installment contract or like a mortgage, so that it's making payments on a periodic basis, perhaps monthly. And at the end of the period of time in which all the payments have been made, the purchaser who's been making the payments then becomes the owner of property, in this case, the mobile home. So this piece of the statute specifically permits these rent-to-own agreements for mobile homes. It establishes a process for how these are going to work, these installment-type payments. As I say, the ownership isn't transferred until the bill of sale is completed and the last payment is made. So once that's done, then ownership is transferred. And it has to, if it's a type of contract, or retail installment contract, or that doesn't meet the requirements that are laid out here, then it's interesting. The statute appears to say that the language that governs it is actually the statute related to residential rental agreements. In other words, standard landlord-tenant. So if it doesn't qualify as a retail installment contract, in other words, the person at the end of paying, say their however many payments, they own it. And if you think about it, logically, that sort of makes sense, because if you're not going to own it at the end, then it really is it's more of a landlord-tenant situation, more of a rental. But that's sort of laying that out specifically. If it doesn't meet the criteria, then it's a rental subject to residential rental agreements, because it's not rent to own if you're not going to own it at the end. All right. This kind of goes to the discussion earlier on about real property versus personal property. In the commerce section here, it specifically provides, this subsection F, that if a mobile home is not financed or conveyed as real property, then it's treated as a sale of goods, right? So if it's not going to be financed the way real property is financed, then this says the law that governs it is going to be, and that law is known as the Uniform Commercial Code, the UCC, that's elsewhere in statute that covers sale of goods. And this says, well, if that's what it is, if it's not residential real property, then it's the law governing sale of goods that covers it. So I think that also sort of logically makes sense in the sense that, well, as we were saying earlier, if it's not real property and it's personal property, then it would make sense that the law that would apply would be the law that covers goods as opposed to real estate. Does that make sense? And that's kind of laying it out there explicitly. Financing is what gets talked about next. And this is also something we referred to earlier, because this is, remember we discussed this, and this is subsection B specifically we were talking about. And this is that if it's financed as residential real estate, and generally it seems to use a shall in one circumstance and a may in another. So in other words, if the mobile home is intended to be permanently sited, for continuous residential occupancy by the owner, shall be financed as residential real estate if it's on land that is owned by the owner of the mobile home. But if it's not, for example, it could be a park where the land is owned by the park owner, then it may be financed as residential real estate. So in other words, it doesn't have to be. And if it isn't, then it could be personal property, goods. And in that case, some of the same laws that apply to protections for someone, for example, who could be evicted, that sort of thing may or may not apply, because it's a different situation if it's being treated as personal property. I think that was something that one of the the other committee members brought up earlier is possibly something you might want to revisit to see, well, is that the way, what's the actual implication? And that's the question that maybe Christelia could talk about and say, well, what does that mean to, when a prospective purchaser comes to a lending institution and says they're going to be using a mobile home as a permanent residence, are they required to be offered a financing of the real estate type? Or can it be denied by the bank on the basis of a conclusion that, well, that's not real property, that's personal property, it's a good. And it'd be a good question. I don't know the answer to it, but it's worth looking into, I think. All right, so, oh yeah, so if it is financed as residential real estate, this is moving on to the next section, this is the deeds issue. So if the mobile home is financed as residential real estate, sort of leaving aside the question of what discretion the bank has, but leave that aside for a moment. If it is, then it has to be conveyed by a deed, right? So like any other real estate, it has to be conveyed by deed. And as with the bill of sale, a form is provided that has to be used. So it has to be used substantially in the following form. This is what the deed is. The form for mobile home warranty deed is right here in statute. So this is what has to be used, essentially. For the deed provision, this next section, this basically deals with the process for how to proceed. Let's say a mobile home was in the beginning was financed by a retail sales installment contract. In other words, it was treated as personal property. But then later on, it's changed to finance. They want to change it to finance as residential real estate later on in the process. You can do that. And this section of statute just sets out a process for how you would do that, steps you would take and how you could change the financing from installment contract to residential real estate, basically.
It looks like you can't change it back.
I think that's right. Yeah, right. It's sort of one way only after you've done it. Yeah. Okay. Next section deals with relocation. So there's a process for filing with the town clerk. If the mobile home is relocated from one municipality to another, there's a way you have to follow this process to let the town clerk know. Again, there's forms provided for that as well. See them, perform relocation forms. There's also a form for transferring a mobile home out of state. That's the second one there. Now, violations of this chapter, again, can also be enforced by the Attorney General. You see that subdivision 2, and there's $5,000 fine maximum for violations that the Attorney General is able to impose. So, and lastly, this is the last section. This is the provision I referenced earlier that parallels the abandonment process that you looked at in Title 10, except in this case, it's that a municipality has the authority to sell an abandoned mobile home. Remember when you looked at it in the first one, it was the park owner who could do it. If it was abandoned, the park owner could go to court and they could ask the court to issue an order to say the court has to make these findings that it's abandoned, but if it does make the findings, there could be an order. This is very, very similar, not exactly similar, but very similar. The difference is that it's specifically for a municipality and it has to be for foreclosure of a tax lien. So in other words, and that under current law is an option that a municipality has. They can foreclose on a tax lien, right? So they could conceivably seize a property and sell it in order to pay off a delinquent tax lien. This provides an alternative for a mobile. So in other words, if there's taxes that are delinquent, rather than go through that foreclosure process, the municipality also has the option to go through an abandonment sale if it turns out that the mobile home actually has been abandoned. There still has to be the proof and showing that it was abandoned. But if that's the case, it kind of provides the municipality with another option, so to speak. I think it's the last, yep, that is the last section in the consumer protection chapter. So I think that's the last of what I had for the walkthrough at least. But happy to answer any questions if there's any now, or certainly come back at another time and talk about it some more as you hear from witnesses about what other issues are that the committee wants to look into.
Okay, anyone have any questions out there? No? Why don't we take a 5-minute break and then we'll come back